223 of Tuesday, 9th November 2021 in case 372, Lisiane Barbier, case 390, Elizabeth Bastien, case 279, Roland Verlack, case 357, Datania Verlack, and case 111, Jimmy Tiran.
357 wasn't put on the schedule, but it's a separate case number. Can you please call the witness?
Mr. Philippe Boulet.
I, Philippe Joseph Robert Boulet, swear that everything I shall say before this commission shall be the truth, whole truth, and nothing but the truth. So help me God.
Thank you, Mr. Boulet. Nice to see you again. Thank you for coming to assist us again. We really appreciate it.
Thank you, Chairperson.
So today we've actually asked you to come in the cases, case 279 and case 357, related cases of Roland Verlack and D'Artagnan Verlack. And it concerns the unlawful acquisition of their family's property, PR 595, which was later subdivided into parcels PR 2109 and PR 2111, and they claim their property was unjustly acquired for derisory compensation, and that following their application for review pursuant to the 1993 constitutional provisions, the land should have been returned to the family. They claim that in 1992 the government began subdividing the property and selling parts of it off, made part of the land a national park, sold a part of it to a hotel for the development of a golf course. And they say that the family had requested the property to be returned to them as much as possible pursuant to the 1993 constitutional provisions, and that the government's sale of part of their land to the hotel following their application for its return was in violation of the constitutional provisions. And they told us that you represented them in a court action seeking the return of the property, and that you could help the commission concerning understanding the fairness of their case. And they also claim that while they eventually received financial compensation, it was insufficient, and before the commission they're again seeking the return of their land. So we hope you can help us. Thank you.
Thank you, Madam Chair. Again, good afternoon. Good afternoon, Commissioners. I must say it is a privilege and a pleasure to be invited here today as a witness to support the case, which is the subject matter regarding the Verlack family. It is without doubt, as I will show later, that there was a great injustice done to the Verlack family. Without saying too much, I can say that the Verlack family in this matter were treated with almost in an insulting manner, were suffered actions which can be described as offensive, with a great measure of abuse of power. And also, which was part of the case, the way parle créole?
I was enjoying that so much. I thought, it's so clear. Yeah. But I guess I have to suffer, yeah.
And of course,
Monsieur
I
Verlack.
blame Mr. Green for not raising the
Yes.
card.
Oh, me, no, I was so fascinated as well. Ou capable de redire sa dernière phrase là encore.
OK, bon, on recommence en créole. Pareil, m'ont dit, c'est un privilège et un plaisir pour moi paraître devant sa commission aujourd'hui comme un témoin pour moi supporte sa complainte que la famille Verlack il mettait devant sa commission. Sans aucun doute, la famille Verlack il subit un grand injustice. Zoti gagne traité avec ce qui nous capable d'écrire comme insulte, avec bonne action offensive et avec beaucoup l'habit pouvoir. Et là, en plus, par là, tout ça, la façon qu'il a veuve, Madame Verlack, si quand il traité, les il objecté qu'ils ont pris sur la terre, on nous rappelle, pareil, son enfant, il dit, c'est la terre qu'il travaille dit pour acquérir, qu'il travaille dit pour travailler sur la terre, pour nourrir son famille, pour faire grandir ses bons enfants. Et bien, si d'une façon honorable, ses bons enfants, ils deviennent bons citoyens, honnêtes. La façon qu'il a traité, là, il objecté, traîne-lui, sortir sur la terre, mettre-lui dans le casseau. C'était horrifique. C'était pareil, nous dit en créole, répignant. Mais il y a quelque chose qui m'a dit, quelquefois, élabore, c'est ceci. Gouvernement, qui permet son l'école, sa qualité action, sa la bi-pouvoir, à cause, il connaît sans doute qu'il a coûté pour supporter tout ça la bi. Pour tolérer toute l'injustice qu'il est capable de faire. Et ça, bien sûr, c'est ça qui m'a pour démontrer. Il y a l'autre quelque chose, à part de ça, qui est quelquefois important pour ajouter, c'est tout ça là n'arrivait et l'avenir. Je pour partager, je pousser partager humblement avec commission bon principe légal qui nous réussit établir et qui nous gagne supporté par désisement la Cour d'appel. Et ça, principe, est très important pour sa caisse. Ça, principe, il dit ceci. Si un dimanche, il fait l'application pour lui gagner compensation, pour lui gagner un remède, on appelle remède parce que c'est compensation, pour lui gagner un remède, s'il fait ça dans l'espace 12 mois, pareille constitution, il gagne demandé. Si, après qu'il fait l'application, le gouvernement il fait aucune transaction avec Salataire, ça c'est une action anticonstitutionnelle. Et n'importe qui la cour, n'importe qui l'autorité, il dans toute légalité pour lui prend ça la terre avec sa dimone que le gouvernement il vend et retourne à son maître. à condition, par ils m'ont dit qu'il fait son application de 12 mois. Après qu'il fait son application, il tient un droit à gagner ça la terre, à cause de la terre, pas de développée. Et qui ça la terre qui pas de développée, qui s'y posait al pour lui, il gagne 20 avec un tiers parti, et une action illégale qui autorisait n'importe quelle autorité, la Cour, pour reprendre à la terre avec sa dimone et redonner à sa applicant. Et ça, c'est non seulement un principe, c'est un principe qui gagne appliqué. Que des dimones, il gagne retourner zot la terre qui gagne vendre avec un tiers parti. Dans un cas, il gagne vendre avec un étranger, dans l'autre cas, il gagne vendre avec un CCLO. Et là, m'a ajouté, bien sûr, c'était quelque chose qu'il faudrait traiter cas par cas. Par exemple, bien sûr, un paramètre, c'est qu'il fait son application et à l'époque qui sa application, tu vas faire, il s'en a droit à cause de la terre, pas de grand développé. Qui arrivait présent, si les gouvernements il fait sa action illégale, qui ne vendait que tiers, sa tiers li in développé. Dans certains cas, quand il grand développé, dans les deux cas qui sont arrivés, pas de grand développé. Alors là, il faudrait nous dire qui est arrivé si une grand développé. Moi, je crois tout le temps, nous servir ce qui nous appelle common sense pour donner la loi une interprétation peu possible. Dans le cas de Verlack, qui développe? Un golf course. Un bout de golf course. Moi, dans mon humble opinion, ça, c'est pas un développement qui s'y posait faire sa dimone, perdit son droit, gagner sa la terre.
I'm just going to, you didn't tell me what the development was. Yeah. Can you just repeat that? Because she didn't actually get it.
Sure. Which part, Madam Chair?
She didn't repeat anything
Okay,
about the
yes.
golf course.
As I said, in this case, what was done was a piece of a golf course. There, I see in there, and that's of course a humble opinion, for the Commission will decide. That is not a development that should deny the person his land. That hotel is not an integral part of a hotel, it's an annex to a hotel, a luxury. All the hotel will lose is a big golf course. They can have a smaller one, there are other golf courses they can use. In the first place, it was an exaggeration to have a golf course on small islands. I haven't seen any in the Caribbean or anywhere else. There was one on Mahé. So I venture that opinion humbly, that this should not preclude the application of that principle.
But would there be anything to stop the hotel? Let's say the land is returned to the original owner. Is there anything that would stop the hotel from leasing it from them?
Exactly. Mr. Grain, this is what should have happened in honesty. You return the land and the hotel approaches. If it's a good deal, they'll take it. They'll sell it, they'll lease it, or they'll lease part of it, keep a bit for them to do a tourism area. The negotiation should not be with the government, should have been with this person. And still now, it will be returned and negotiations will go. I wish to add something also. Ah, pardon. Oui. Oui. Si retournait, bien si, ça, l'hôtel présent discute avec son vrai maître. Nous pas là pour décider l'eau qui arrivait dans le domaine commercial. Et ça y amène nous directement l'autre point. Avant l'air qui moelle dans sa bande document. L'autre point. Ça, l'exercice qui nous peut faire, son grand valeur, c'est la réconciliation, en premier, au-delà de la vérité. On n'a pas oublié que ces lois, ils gagnent accusé qu'ils sont xénophobiques. Moi, je là, commencement, les touristes qui viennent, les étrangers qui viennent. C'est ces lois qui gagnent reconnaître par tout bon étranger comment un peuple est plus accueillant qui est capable d'imaginer. Et moi, comme touriste qui est étonné par ça l'accueil. Bien sûr, il y en a une raison historique à cause de l'accueil spécial. C'est un des. Seychelles et Maurice, c'est un des peu destinations touristes, côté waitress, il est capable de la table en anglais, la table français, et c'est les autres en anglais, les autres français. Je ne suis étonné par ça. Mais ça, c'est une petite anecdote. Jamais c'est celle xénophobique. Mais en nous, présent, dans sa optique et sa réconciliation, en nous, réalistique. Il y en a beaucoup, c'est ces lois, qui ne souffrent de la main étrangère à travers connivence avec gouvernement. Et c'est ça qui crée ça resentment, ça sentiment un peu offensif envers étrangers. Et ça, c'est un cas typique. Quand ça a besoin de rester l'eau, l'équerre, la famille Verlack. Les autres familles, c'est ces lois. Nous avons un gouvernement, c'est ces lois. Un étranger vient dit mon la terre, ça c'est ces lois. Et le gouvernement, il rentrait en connivence pour détruire droit à ces lois, pour donner faveur commerciale pour enrichir la compagnie étrangère. Mais ça, c'est une aberration totale. Ça rend qu'il besoin de rester en nous réalistique, lesquels c'est ces lois. Voir étrangers pézouiller les autres la terre. Et c'est pourquoi qu'ils m'ont mentionné avant, sa nouvelle jurisprudence, je crois ça, il forme partie de la réconciliation. Nous réconcilier ça qui dans les cœurs, c'est ces lois. Qui y en a dans son les cœurs? Qui a besoin de sentir la justice? C'est travail sa commission. Et c'est bon, c'est pourquoi mon mettait l'opinion humble, que ça c'est un ordre qui pour montrer non seulement illégal, mais là il y a entièrement dans la ligne réconciliation. Malheureusement, Mme Verlack pas là, mais son enfant dans son souvenir a gagné un soulagement dans tout son effort qu'il fait dans la vie et pour son protestation honorable. Et quelquefois les autres aussi qui souffrent à travers la connivence gouvernement qui est étranger, comme la terre qui nous prend, et que c'est ces lois qui ensuite nous vendent avec étrangers. Et ça, il va donner un message de la justice pour beaucoup de monde. Avec sa petite introduction, si vous permettez-moi, présentement pour faire un petit voyage à travers sa banzisme, pour établir sa l'injustice et pour montrer sa côté qui nous est arrivé aujourd'hui après tout ça là. Bon, il faut dire qu'il est rentré dans sa bandisme. Ça, l'espoir qui sa constitution t'y emmenait, surtout en ce qui concerne réparation à l'injustice la terre, ça grand l'espoir, si gagne écrasé par la Cour constitutionnelle, dans une série de cases depuis 1993 jusqu'à 2007. Tout ça bonne l'année, toute application qui gagne écrasé avec un seul but pour soutenir bonne action gouvernement abusive et illégale. Et ça qui m'ont commence par montrer, quelquefois, juste pour aider dans sa petit parcours, si vous permettez-moi un peu de temps pour ça, il est important de nous lire sa banzisme pour nous en tête sa fameuse Schedule 7, Part 3. Permettez-moi de donner copie chaque commissionnaire. C'était ça, sa section Constitution. Yes, there's one for each. Qui ne fait tellement dégâts dans sa pays. Avec ça en tête présent, avant qu'il nous rentrait dans Isban, on lui montrer sa commission, qui qui n'arrivait dans la tête sa gouvernement, qui maniait ici, qui sont ici portés par la Cour. Moi, non, là, pour nous commencer nous parcours, ça bonne lettre qui gouvernement écrit jusqu'à l'heure qui nous tient en cours. Il y a tassé avec un affidavit, mais non pas pour nécessairement parce que ça affidavit, mais si nous sommes capables de passer ensemble l'eau sa bonne lettre. Sa bonne lettre, son chronologie, is en l'air jusqu'en bas. Nous commençons avec première lettre en l'air et nous finissons avec ça qui est en bas. Quelques fois nous allons ensemble. Voilà première lettre. Première lettre est adressée à M. George Verlack. Fiduciary for Mr. and Mrs. Verlack. Pas des autres présents à cause de quantité pour jouer l'autorité, M. Verlack. On tient en cours pour appointer M. Georges Verlack comme fiduciaire. Là, la Cour rend son jugement. Il dit appoint you executor to act as fiduciary. Créer une petite confusion. La Cour saute l'eau là pour lui faire un tas d'acrobatie.
Monsieur Boulet, en effet, not being a very legally oriented person, il y a différence entre fiduciary avec exécuteur. Oui,
OK.
Comme ça.
OK. Dans ce cas, il y a des autres différences. Si un dimoni est mort, avant le Code civil, il vient en force. Nouveau Code civil. Autres en a ce qui nous appelle la saisine. Autres viennent propriétaires directement. En bas, ancien code, enfin code français, des études. Et alors, autres viennent automatiquement par l'opération la loi, bonne co-honneurs. Après Civil Code, nous dit, ben non, pas capable de la saisine à cause d'un temps embrouillé qui passait. Alors, si toute l'autre division de la terre, lundi, monument, nous pouvons besoin à pointe un exécuteur. Mais si on mort avant, et qui dit, mon y en a la saisie, ou vient co-honneur. Et bon co-honneur, vous avez besoin un fiduciaire. Vous n'avez pas besoin d'un exécuteur. Mais ça, exécuteur, après le Civil Code, là, la loi dit, ou poisie comme un fiduciaire. C'est-à-dire, toute transaction, toute décision, il besoin passe à travers. C'est où qu'on a droit de distribuer. Par exemple, exécuteur, il y en a certaines actions qui besoin de faire, qui est fiduciaire. Fiduciaire, il ici prend sa propriété, qui tout le monde, il y en a. Exécuteur, il y en a des devoirs pour faire l'inventaire de quels héritiers. Un inventaire, qui ça qu'il y en a dans sa estate. Ensuite, propose une distribution estate. Mais là, pendant qu'il peut faire ça, là, il tenisse à la terre. Son devoir exécuteur, son devoir fiduciaire, c'est un devoir que la loi, il dit, on a besoin de tenir sa bonne la terre, sa bonne bien, en bonne foi, en pater familial. Ou besoin de protéger. Ça, c'est au droit fiduciaire, pour protéger bien qu'on a. Après, il y en a...
Juste un petit peu clair sur l'esprit. Ça va, du monde qui choisit pour une exécuteur ou bien fiduciaire, c'est dans la mesure qu'il n'a pas un will ou bien irrespective of si un will ou bien n'a pas un will.
Irrespective.
Irrespective.
Si n'a pas will, ou besoin aller devant la cour, faire appointment of executor. Si on a un will, on peut faire pareil. Seulement si dans will, on a droit à appointer exécuteur. Si on fait ça, voilà en cours pour un procédé qui nous appelle confirmation of appointment of executor.
Okay.
Pour gagner sa petit papier pour deal avec.
Thank you.
So this is the
Interpreting everything he says, so I'm just getting bits.
Okay, shall I go a bit slower? Let me slow down a bit. What I was mentioning
I was trying to understand the difference because I hear...
in reply to Bishop, before the Civil Code, everybody who inherited had what in French we call saisine. Saisine means you automatically become the owner. The person dies, you become owner either by virtue of the law of intestacy, if you haven't done a will, or you become owner by virtue of the will, but automatically. After the Civil Code came into force, saisine was abolished, everything vested into an executor, who then distributed the estate in the names of the heirs. It was an intermediary point. And in this case, Monsieur Georges Verlack had been appointed fiduciary because the father had died before the Civil Code. And of course, Mrs. Verlack, in her own right, was also. Now, if we just look at this first letter, unless there's other questions, compulsory acquisition of parcel PR 595 Escalating, Prale, 96. An address to Mr. Georges Verlack. I refer to discussions held with our technical advisor regarding compensation in respect of the above acquisition. I wish to confirm the government offer of compensation as agreed by yourself. Viz. The return of parcel 2109-2111 to Heirs Verlack as shown on the attached plan. There we are. We've agreed to return the land, and this should be the end of the matter. only sign a document. Next, cash compensation, 400 payable in 2 installments, 9 p.m. on the balance outstanding. That is for certain parcel that had been taken and built on. But the contention are these 2 first parcels. The above offer subject to the following condition: the return to government of a strip of land shaded in red on the attached plan to facilitate maintenance and access to the main drain outlet, the destruction of a right-of-way along the boundary of PR 2111 to parcel PR 1632 to provide access to the occupants of said plot. The survey referred to in A and B above will be carried out subsequent to the transfer of parcel 2109 and 211 to Heirs Verlack. I would appreciate if you let me know whether the above is acceptable to you. Then, of course, Mr. Georges Verlack replies, "Thank you for your letter of 8 February. I agree with the conditions referred to in your letter. Under reference, with the exception of the, I wish to propose that instead of a strip of land shaded in red, which is a small plot of land, that a right-of-way of 3 meters wide be demarcated and returned to the government, which will provide the access to the drain outlet. I hope that you will find my proposal acceptable with regard to the matter and settle. I look forward to hearing from you soon, and thank you very much for your understanding and cooperation." So that is done. It was settled.
Can I ask one question? I mean, can the government put conditions on the return?
That was, in fact, no. This should be settled afterwards. That Schedule 7 permits no condition if the land is undeveloped. Certainly, that's a good. So that was settled, and you remember the condition of 400,000. That is paid. That the agreement for return of the land and payment of compensation of 400. So we have 200,000 paid. Then we have the other 200. Next letter with number 4 on top. The balance is paid. All's well. We're going ahead. Then all of a sudden we have this. I referred to our telephone conversation regarding the return of part of the above-mentioned parcel to Mrs. Idea Verlack and Heirs Verlack. The Attorney General has not been able to finalize the transfer of the property, as your appointment executor is only in respect of land owned by heirs of the late Médéric Verlack at the time of the appointment. I pause there. This is nonsense. The estate comprises of everything, including a contingent claim. Including any contingent claim that arose. But
What does contingent claim mean?
well, if the law changes or if something happened.
Okay. Mm-hmm.
I do not wish to make heavy weather of that because I'll go through the judgment later. As the property is being transferred to Mrs. Idea Verlack and all return heirs of Mr. Médéric Verlack, the heirs, if they are not in Seychelles, should appoint you to accept the transfer on their property. Now, all that, of course, the bad faith starts there. It was easy for government to return Mrs. Verlack a half share in the property.
Yeah.
The heirs who was here would be returned their share. You can return shares, you can transfer shares under Seychelles law. So the excuse starts. Then we have for Mr. D'Artagnan, who writes a letter. I, D'Artagnan Verlack, refuse to appoint my brother Georges Verlack at the present moment as executor of parcel due to the following. And of course, government knew much better. He cannot refuse to appoint an executor. We are not appointing executors here. The executor has been appointed by the court. Enfin, we should have taken his language for what it is. He would say, well, for the time being, I don't want Mr. Verlack to finalize this. Not appointment as executor. The total parcel is 2,000, parcel land to be returned, acres, parcel of land returned by government. And of course, you will see his problem is with the price.
Not with the appointment.
After considering the above, I trust you will be in a position to understand that we have been grossly undercompensated to the land retained by government. At present moment, the government are selling land at so much. I would like to make an offer to government to return 11 acres anywhere on Prahle and will pay the government so much. He is disputing the value, albeit from a long distance. Mrs. Melly, the point I am trying to make is that fair and agreement is rich. I am not prepared to come to the party. I trust you will appreciate that I have waited for 20 years for the justice as agreed in the Constitution, and I now feel that it is not the case. Please fax me. Now, okay, this was a little irrelevance. They would have transferred everybody their share, which was the way it was going to be done. Everybody would have a share in that property. Then they would decide. Government goes back. I refer to your letter addresses to Mr. D'Artagnan Verlack. I refer to your letter of 26th of August regarding the above. I am disappointed to hear that you have decided not to come to the party. What a party. And refuse to appoint Mr. Verlack to accept on your behalf the property being transferred back to the... No, that is not what Mr. Verlack has said at all. For your information, the property being retained by government is mountain land, and we believe that the compensation offered is fair and represents the open market value of the property of the land at 1993 as provided under the new Constitution of Seychelles. The agreed monetary compensation has already been paid to Mr. Verlack in his capacity as fiduciary. I wish to point out that if you continue to refuse to come to the party, the property being returned by Heir Verlack, which is primarily the whole of the plateau area, will remain in government ownership, and you would be unable to carry out any dealings with said property until such time that the matter is resolved. No, Mrs. Verlack owns half of this property. Why should she wait for D'Artagnan? She owns half of that property. And Mr. D'Artagnan owns 1/8 or so, 1/9, 1/18, because it's 1/9 of half. Then, of course, we have Mrs. Melly. Now to Georges Verlack. I refer to our letter of 14th May regarding the return of part of parcel 595 to Mrs. Idea Verlack and Esbedek Verlack, and to Mr. D'Artagnan Verlack, letter of 26th of August, 1997, copy of that. We note from our record that you have to date not been able to obtain the agreement of all the heirs to accept our offer of compensation of 18th February. Well, he has already accepted it. They've already paid the compensation of 400, but there you are. I wish to inform you that if you cannot secure and produce written agreement of all the heirs to the above-mentioned offer within the next 4 weeks, what is that? Putting deadline? 4 weeks? You can wait for 10 years if they want.
Mr. Bull, excuse me a minute, but isn't there something to do that a fiduciary is supposed to act in the best interest of all the heirs, and once a fiduciary has been appointed, the individual heirs cannot go and, in other words, they've transferred their interest to the fiduciary.
Yes. They transfer their interest to the fiduciary who negotiates on their behalf. But under circumstances, you need the agreement of all the co-owners. For example, a fiduciary cannot sell. Okay? Cannot sell a property without the consent. But here, we were talking of a negotiation with a common intention of getting the property. And that was the greatest benefit of the heirs. So that was not in doubt. Mr. D'Artagnan from far out had a problem with the monetary compensation, which Mrs. Melly should have said, this is already settled. Not only settled, but paid. I wish to inform you that you cannot secure any written agreement of all the heirs to the above-mentioned offer within the next 4 weeks. We will assume that the co-owners are not interested in the return of the land, and government will proceed on the basis of monetary compensation in respect of the city. What absurdity! So if they cannot get the land, how can they get compensation? If you need Mr. Verlack for the return of the land, you don't need him to agree to the compensation? This was such absurdity. So you can see now where they're trying to wiggle their way in a very weak way. The government will decide, not the Constitution. Let's forget the Constitution. Government will decide and will proceed. Government will proceed. What right do they have to proceed to Constitution? What right do they have to put 4 weeks? This was a massive abuse. This is what I was saying, a huge abuse of power. You had this land, it must be returned to the heirs. It was undeveloped, and you recognized it, that it was due to be returned. Now, all of a sudden, you give yourself the power to pay compensation? Of course, we understand why. Let's look at the next letter. Yeah. I refer to my letter of 25th May and your subsequent discussion with the technical advisor in connection with the land requirement for the proposed Lemuria Hotel and Golf Course project at Escalating. I wish to confirm that government wishes to make you an offer of compensation of 900,000 plus the transfer of parcel 2109 and the portion of land edged green on the attached plan as full compensation for the compulsory acquisition of PR Australia. Now they are dealing with the land. And this is where the connivance happened with the hotel. This is where the government is now conniving, that edges on corruption. When you have a constitutional obligation and you are now conniving, it's a proposed Lemuria Hotel and Golf Course project. So here we go on, if I may, George Verlack. I refer to our letter 13th August and to discussions held with yourself on Thursday, 4th of September 1998, regarding the portion of parcel PR95 proposed for the golf course project. I wish to confirm the following options put to you in the above-mentioned meeting. An increase in compensation offered for parcel 211. In this context, government is prepared to review the offer made on 13th August 1934. The offer is valid. Why change the offer? What's your concern with a commercial transaction? Transfer of part of the property acquired for the golf course to the Refuge du Pêcheur in return for equity participation in the hotel and golf course. Government now is acting on behalf of the company instead of the government of Seychelles, offering shares in a company. Total absurd. Under the land acquisition, under Schedule 7, the government is offering shares in a third-party company. Lease of the portion of land required for the golf course to the Refuge du Corsaire for a period of 60 years, which is commensurate with the lease of other state-owned properties to the company. So we've leased some properties, you must do the same. In return, government would be prepared to reconsider the position regarding the mountain land.
Is that blackmail?
That is, you know, when faced with a constitutional obligation, this kind of acrobatics is nothing short of shameful.
Why did it originally say it wasn't returning the mountain land?
They had said to be returned. And now there's this connivance. As agreed, Mr. Savi will also discuss with the golf architect. Now they're involving this family with golf architects. Well, all they want is their land for them to develop themselves. Golf architect. And the government now is involving the golf architect. The possibility of increasing the size of the 3 residential plots to be returned to Verlack from the proposed 500 meters. So we will discuss, no, forget the government. We discuss land now with the golf architect, how much land you will get back. I would appreciate if you would confirm which of the options is acceptable to you. Now they're putting option, nothing has got to do with the constitutional options. Finally, we have everybody, then the right to everybody now, confuse everybody. I refer to our prior,
Earlier correct.
oh yes, earlier, sorry, mine is with Mr. Georges Verlack, and culminating in our letter of 10 September, which to date is unanswered. It has since become evident that Mr. Georges Verlack is not fully empowered to deal with the rights of all the co-owners in the above-mentioned property. It is therefore necessary that government communicates directly with you in the. So now they're churning up this Georges Verlack, whom they paid. They paid money, they paid 400,000. Now all of a sudden we have to ignore him. Let's go to everybody. It has, as already explained to Mr. Georges Verlack, the Escalating Hotel course project is of national importance to Seychelles.
As they say every time.
Yes, yes, to Seychelles. And in order to accommodate part of the proposed 18-hole golf course, it is necessary for government to retain parcel PR11. So government now is acting on behalf of a commercial, crushing a Seychellois family and going for the commercial foreign company. Construction of a hotel is in progress and is expected that works on the golf course will commence in January. What has got that to do with the Verlacks? Or the Constitution? Government therefore wishes to make a final offer payable to the heirs in the sum of 2.1 million plus the transfer to the heirs of parcel PR 2109 as total compensation to all the co-owners as heirs in respect of the compulsory acquisition of PR 595, also Escalating Prale. The offer includes a review of the compensation paid in respect of the mountain land. Are they allowed to review? The above acquired the sum of 400,000 previously paid will be paid by a first installment of 400,000 at the end of January 2000, and the balance in equal half-yearly installment over a period of 2 years with interest at 4% at the reducing balance. Now, of course, they've cornered themselves because they've addressed everybody. And nobody accepts that.
But it's interesting that from August 1998 to December 1998, the amount proposed as compensation has gone from 900,000 to 2.1 million.
Correct. It
I
just
mean, on
goes
what
up.
basis?
Correct. Women
Comment vous
fancy.
évaluez ça la tête de sa façon?
Exactement. Constitution. Only constitution.
Oui.
Where is the constitution has been thrown away regarding compensation, regarding everything. They're treating it as their land.
Yeah, and it's all arbitrary, comme si...
Exactly, Mrs. Barnes.
Décidé dans les airs.
Exactement. Vous prenez 4 semaines. 4 semaines, nous allons là, vitement. Never mind, the Constitution was in 93. I am instructed, then we have the letter of the 8th of January. I'm instructed by my client, Mr. George. Okay. I am instructed to acknowledge receipt. Oh, that's my, then they come to me. Then they come to me. With all this melo, which is not making sense, we try to put it back on rail when they come to see me. That's my first involvement. I am instructed by my client, George Verlack, to acknowledge receipt of your letter of 10th of September 1988 and 22nd December 1998. My client is somewhat mystified by the statement in your letter of 22nd December 98 that it has since become evident that Mr. George Verlack is not fully empowered to deal with the rights of all the owners in the above-mentioned property. My client has been duly appointed fiduciary in respect of the above-mentioned property and is as such fully empowered to deal with the property at the exclusion of all other parties. The fact that my client may need the consent of the owners at the appropriate stage does not in the least reduce his power, but on the contrary, enhances the power as the owners are, as a result, precluded from dealing with the property, except through a fiduciary, and their consent can only be given through a fiduciary. At this juncture, my client, in his capacity as fiduciary, has instructed me to confirm that he considers the exchange of correspondence dated 8th of February 1996 and 18th of September 96 to have concluded all negotiation and embodies the agreement reached between the parties. So this is the original letter where they accepted, returned the 2 parcels, I pay you 400, which they paid. We said this now, we cannot go further. This is the agreement. Let us go according to that. And you have considered it final, you've paid with all the others are not constitutional. Then I put this. Regarding the various parties interested in the land agreed to be returned to us Verlack, my client will deal directly with all interested parties once the land is returned. In the light of the above, and in accordance with the agreement reached as set out in your above-mentioned letter of 8th of February 96, my client looks forward to the return of parcel PR2109 and PR11 to AS Verlack. My client trusts that the return of land can be effected shortly, as the owners have been waiting for a long time to get back their land. And their reply, then there's a letter from then Mr. D'Artagnan, who goes across there and far from in Australia. I am in receipt of a letter dated 22nd of December 98, received today. I am very happy that you are now acknowledging that you have to deal directly with me. Before any decision could be made, it would be appreciated if you would please provide me with the following information. For the 0.5 acres referred to in your letter as mountain land, whereby you stipulate that reviewing the compensation awarded, it would appreciate if you could let me know what sum was for the 11 acres. Again, this is compensation. How much acreage will the government take to accommodate part of the proposed Enifol golf course? What will be the compensation proposed the Verlack has for the land acquired to accommodate part of the proposed golf? how much acreage that parcel 2190 comprise of. I fully understand the project is of national interest. Your immediate reply to the above. That is one heir going his way. That doesn't derogate from having to return the land to the heirs. It's just a red herring. Then there's a reply from Mrs. Melly. I refer to your letter in which you requested certain information regarding the above measure. The reply to your query is as follows. The value of the mountain land, so many acres, has been reviewed to 600,000. An extent of 4.955 hectares is required by the government from the Verlack property to accommodate part of the golf course. Government proposes to pay 1.5 to Verlack for the land required for a golf course. Parcel 2107 being returned to the heirs has an area 2,671. That's half an acre. I trust formation will help you, and I hope to receive a reply to our offer. So his reply is more important than everybody. So they're hanging on to that straw. Then we go back. I refer to your letter regarding the above mentioned. So they reply now to my letter. I wish to inform you that the statement made in our letter of 14th May 1997 was based upon the Attorney General's advice. According to the Attorney General, Mr. Verlack was appointed to act as executor in respect of land, which was in ownership of Mr. Frederick Verlack at the time of the appointment. All of a sudden, he's executor. Before that, he was fiduciary in the first letter. Also, the appointment made by the court is not an appointment of Mr. George Verlack as fiduciary, but as executor to act as fiduciary for the co-owners.
What does that mean?
And the application was for fiduciary. Consequently, his appointment does not authorize Mr. Verlack to act as fiduciary for heirs Médéric Verlack. Attached is a copy of a receipt from Mr. D'Artagnan Verlack in reply to our letter. It appears that the letter, and from previous correspondence with Mr. Verlack, that he has not authorized Mr. Verlack to act on his behalf.
But is that a confusion again on their behalf, or they're just trying to...
No, they're just trying to infuse as much confusion as possible, because now they've already had a deal with the hotel.
But they're trying to make a difference between, I mean, this is why I was asking for definitions of fiduciary and executor.
And he was appointed, the first letter, he introduced himself as fiduciary, and he was appointed as a fiduciary, the application. And they paid him as a fiduciary the 400,000. So now he has a letter from Mr. D'Artagnan Verlack. Anyhow, we reply. Again, thank you for your letter dated 20th January 1999. Regrettably, I cannot agree with the Attorney General's contention, as set out in your letter, in view of the fact that an executor is not appointed in respect of specific land or property. An executor is appointed under the Civil Code in respect of the estate of a deceased, and an estate comprises absolutely everything that belongs to the deceased. Be the above as it may, all the heirs of Mr. Médéric Verlack have appointed my client, Mr. Georges Verlack, as their agent, as per the attached power of attorney. So now we got a power of attorney from all of them. And Mr. Verlack is, as a result, therefore empowered to negotiate with the Seychelles government on behalf of the heirs. Now that we have resolved the issue of representation, I wish to reiterate on behalf of my client that all the heirs desire the matter be settled in accordance with the agreement reached with their agent as set out in your letter 18 February 1996, and they trust that the return of parcel PR 2109 and PR 111 will be effected without further delay. Then no reply. I am instructed by my client, Mr. Georges Verlack, acting on behalf of heirs Médéric Verlack and Mrs. Idea Verlack, that unless a deed of transfer is executed to register title PR 2109 and title PR 11 in the name of the owners within 1 week hereof, my client will take legal action. So Mrs. Melly replies, Government has communicated its decision to retain the above-mentioned parcel of land in the public interest by its letter to Mrs. Idea Verlack and all the heirs of the late Médéric Verlack, dated 22nd December 19. The letter also explained government's position in regard to parcel and the compensation to be paid. Therefore, any action filed in respect of all land will be resisted. Now, so I went through that because it is important. They forgot the Constitution. But why should they care?
Retourne encore, Président.
Oui. Là, nous voyons tout ça bonne lettre. Thank you for the reminder. Là, nous voyons tout ça bonne lettre. C'est une plie Constitution complètement. C'est une pliée, c'est Constitution, pas de rien pour faire avec tout ça là. Mais à cause de plier, de faire ça qu'ils ont fait. À cause de si qui la coupe ou si porte, ça qu'ils ont fait. Ils ont pris un bout de la terre, ça bon du monde, ils ont d'accord pour rendre autres, ils ont pris un bout, ils ont donné étranger, ils ont augmenté, ça n'a pas de rien fait. Mais la coupe pour les autres, alors, ils ont allé même. Et là, par exemple, pour montrer les autres, qui manière, qui la cour, une réussit pour effectivement soutenir ça, en s'en servant sa schedule 7. La façon qui. Mais là, pour montrer tout ça, il faudrait, on mettre la phase, arrive 2007, tout ça bandisement, il est renversé, un après l'autre, inclus spécifiquement gisement Verlack. Il est déclaré inconstitutionnel par la Cour d'appel. Mais on nous allait. Alors, bon point là. Alors, dans ce gisement de la Cour constitutionnelle, moi, pour faire certains points, vous avez dit, OK. OK pour gouvernement, pour un bout de la terre, pour donner. It's quite all right. Change circumstances, OK. À cause, écoute sa raison-là, et bon, pour montrer, à cause ça, n'a pas aucun devoir mandatoire au gouvernement. Ça, schedule, ils ont d'autres indiscrétions pour service au gisement. So, it's not mandatory. There's nothing mandatory in that. It's only directory.
But it's in the Constitution.
This is what the Court of Appeal is going to spell out later. Very, very forceful. So change circumstances. Okay, it's Monday. It's directory. And then a very interesting thing happened. This is amazing, and this also was reversed later, completely. So they now the Court of Appeal is trying to crush it as early as possible because it's an embarrassment with Mrs. Verlack having been dragged in jail. So they call us. Ah oui. Si sa caisse, tout il y a un seul coup. À cause, s'il vient l'embarras pour le gouvernement, et la Cour suprême, si besoin, c'est pas le gouvernement, là, ça l'embarras, Madame Verlack, qui a arrassé son propriété, qui a mis dans la Cour. Alors, la Cour constitutionnelle, il appelle nous. Ça, c'est the best one. Il dit, nous, mais là, ça point exécuté, là. Fiduciaire n'a pas un problème. Et mon roi qui ont payé crush l'eau ça point. Alors, moi, vous dites n'a pas un problème. Mais moi connais ça, c'est la boîte qui payé servi. Alors, moi retourne, moi file une motion. Pour tout le monde dans sa pétition. Ça veut dire, mon petit une pétition devant la Cour, qui pétitionneur, c'était M. Georges Verlack, en tant que fiduciaire, représentant les héritiers Médéric, et second petitioner, c'était Madame Verlack. N'a pas contention de Madame Verlack, il a moitié. Zot peut jouer l'OSA, Monsieur Verlack, parce qu'il y en a l'autorité, entrer dans civil code, entrer dans tout ça. Moi, mais là, mal dans le bureau, comment m'ont senti, zot peut alzet ça, sa technicalité, m'ont fait une application pour que tous les héritiers ils viennent petitionneurs. Ça veut dire que je déclare à M. Verlack, il ne peut pas affecter pétition à cause de tous les héritiers ils viennent petitionneurs. In their own rights. Pareil, ce que tu fais dans d'autres lettres. Mais là, c'est quelque chose d'intéressant qui m'a besoin de reverse en 2007. Je dis, bon, ben, après l'accessisme, ça dit qu'il un coup. Nous tenons un mois pour nous faire une pétition. Ou pétition, il y en a d'autres. On y a aidé. On fait les lits dans un mois. Mais présent, si on ajoute les autres du monde, ça bande du monde, autres pour venir après un mois.
Ça est l'autre raison que je donne.
Ça est l'autre raison. Et
Letting
ça,
rise.
it's time bad. Et ça, la cour, par mon trésor plus tard, qui m'ont dit, la cour d'appel, c'est crase ça. In very, very forceful language. Bon, par un petit coup d'enregistrement. On nous voit Constitutional Court. OK? Dans Constitutional Court, il y en a 3 gisements. Mais nous pouvons concentrer dans le gisement président, because it was the leading, à cause c'était ça, président Constitutional Court, à cause ça, c'était the main one. Ça qui m'ont fait, pour Madame Chair, à cause quelquefois pour archive, m'ont mis tous les 3 gisements. So that you can apprendre dans ça, dans record. Ça, c'est pour Madame Chair, s'il vous plaît. Et pour les autres commissioners, this one, so I've given all 3 judgments for the records. As I will be referring to the main judgment, I am giving the commissioners a copy of the main judgment, which is the judgment of the chairman of the Constitutional Commission. This is just to show, as my witness here, I'm called as a witness to show the fairness of the. So we'll be looking at the judgment of Judge Pereira, who presided the petition. Can I invite the Commission to look at page 6 and 7? The numbers figure at the top of the judgment. We will start with page 6. The last paragraph. I've picked certain paragraph which will show the attitude of the court. I will read that with the Commission. That letter was replied by the Ministry by letter of 25th December 1997, wherein the intention to transfer both parcel PR 2109 and PR 2111 was reiterated, provided he agreed to appoint Mr. George Verlack to accept the property on his behalf. By letter dated 25th May 1998, the government continued to make the offer of compensation of 8th February 1996, still open for the further period of 4 weeks. Oh, that is endorsed. Pending the agreement of all the owners, and inform George Verlack that, next page, if you cannot secure and produce written agreement of all the heirs to the above-mentioned offer within 4 weeks, we will assume that the ex-owners are not interested in the return of the land, and government will proceed on the basis of monetary compensation in respect of the same property. So that is endorsed. Quite all right. You have no power to accept the land. Now I'm going to give you power to accept compensation. Then the next paragraph, the government throughout its correspondence maintained that the letter dated 8th of February 1996 contained an offer of compensation. The offer was to transfer both parcel PR 2109 and PR 111 and the payment of monetary compensation for the balance of portion parcel 995. But the offer was agreed upon by George Verlack, who misrepresented himself as the executor of Mideric Verlack and Fiduciary. Misrepresented himself? It's so insulted. He had given his appointment, misrepresented himself as the executor of the estate of George Verlack. Now it's a difficult act to support, it's an embarrassing act to support the government who has been so abusive. So in defense, they attack. Sadly, that is occurred. There was no reply to the letter of 25th May 1999, and hence the government was entitled to proceed on the basis of monetary compensation. What entitlement was that? The Constitutional Court, without shame, gives them an entitlement?
And the government had given itself this entitlement.
Exactly. No, you must repeat it. They must be covered 100%. So they are entitled. Without quoting the law. They let the law. The law is the law doesn't come in the way of a good conclusion.
But there's no law that entitles the government to do this.
As stated therein, and consider that the ex-owners were not interested in the return of the land as offered by letter. So this is the conclusion. They're not interested. But they're interested in, and where do they find that they're interested in monetary compensation is something. Just to give you a taste. You know, reading the whole judgment is a nightmare, but we have limited time, so respecting the time, I have just picked up. If we can look at page 15 and 16. Page 15, I will read the last paragraph, which starts with admittedly. Admittedly, parcel PR 595 was acquired from all the co-owners. Hence, if any contravention of the provision of the Constitution was being alleged under Article 1301, all the co-owners who now seek to be added ought to be petitioned this court within 30 days of the alleged. This is where they are going to throw everybody out, because now there's no other way. George Verlack had negotiated with the government and filed a petition dated 24th September 1999, in a capacity which he never was. He still continues to claim the capacity of executor and fiduciary. He doesn't claim, he was appointed. Section 112 of the Code of Civil Procedure gives a discretion to the court to add parties, that's the best one, who ought to have been joined or whose presence before the court may be necessary in order to enable the court to effectively and completely to adjudicate upon and settle all questions involved in the cause or matter. This is what I argued. I am of the view that this discretion should not be exercised in a constitutional petition. On the contrary, any sensible person, this is where it should be exercised. As an exercise of a constitution. The excuses given were unbelievable. Where the persons sought to be added are in default of Article 130 read with rule regarding the filing. And of course, I will later produce the Court of Appeal, which says they can wait as long as they want. There is one constitutional prescription, and the prescription is 1 year. No law can double a prescription. So there you are. And I'll just go to the next page and read, as I say, I've just chosen paragraphs. The next page 15, next page 16, I will only read the first paragraph. Section 122 cannot be applied to cure such defaults. No, we cannot cure that, especially due to the nature of the petition filed under Article 133 of the Constitution. Accordingly, the motion dated May 2000, seeking leave to amend the petition by adding that street is dismissed. Suffice to read that to know how unjust that petition was. And I later will show you all these things being addressed. There they are claiming constitution, they are out. Strictly speaking, they were not out. Well, the Court of Appeal later said this doesn't apply because there's a constitutional, let alone their representative was there. So then I will invite the court to go quickly through this, to look at 23 and 24. To look at 23 and 24.
Pages 23 and 24.
Yes, I'll look at 23 first. This was the position which was later argued in cases that reverse Verlack. So this was at page 23, the first paragraph, the last 3 lines of the first paragraph, which starts the petitioners. The petitioners consider section 14.1 and subsection A, to which the facts of this case relate, as purely mechanical process. To them it is an irrevocable end to the constitutional undertaking. Then we go to the next page. That was my submission, which I later convinced another court. If we look at 24, there's a first paragraph. In the middle of that paragraph, there is a sentence which starts with a view to, and that is in inverted commas. Now, with a view to is what is in Schedule 7. You will do that with a view to doing that. You will negotiate with a view to doing that. So this is the president interpreting that. With a view to means with the intention of. Hence, negotiation in good faith are required to be done with the intention. Now he's substituting it. He's rewriting. He says with a view of transferring back in the situation set out in subsection A or B of section 14.1. It is therefore only directory and not mandatory. Hence, directory doesn't bind the state that. You know, when remember reading that judgment at the time and said, I will carry on until one day it is reversed. Hence, national interest predominates the constitutional undertaking given in Schedule 7 to compensate for past land acquisition. Then, the next paragraph, the final sentence, second paragraph, the final sentence, 4 lines from the bottom of the second paragraph, the sentence starts, the petitioners. Second paragraph, from the bottom, 4 lines from the bottom, it says this. The petitioners cannot seek to implement the decision conveyed on 8 February 96, as that decision was validly varied. So everything is valid to the change in circumstances in the process of continued negotiation that arose as a result of the legal incapacity. So everything, when I mentioned at the beginning, government could do whatever they want. And everything is effectively just endorsed, however absurd the reasoning was, it did not distract them. Okay, so
This is written by Fernando. Oh yes, he can play about with words so well.
So we have, I hope I've given an aperçu of how government got the support of that. If we put that judgment aside, you know, many of my clients were saying, and I cannot blame them, you know, this court was adding insult to injury. and they were so right. Fortunately, it was all reversed in 2007 onwards. Now we have here, we have the Court of Appeal. The Seychelles Court of Appeal they delivered, let me see, they delivered a unified judgment. I have a copy for each of the commissioners and Madam Chair. 5, yes. Basically, they endorsed, as was expected, they endorsed everything the court said. The out of time, the directory, government could swap from one to the other. So I will only pick, as I say, time is precious. I will only pick what's very important. All to say, they agreed 100% with all these points, which are points. But it is important. Why I point to that is because in another judgment, the Court of Appeal said they've understood nothing of that paragraph. They didn't understand what it means. So if we look, if I invite the Commission to look at page 8 and 9. Again, the pages are on the top of the page. Si mon capable invite commission pour get page 8, second paragraphe, qui m'a dit à cause intéressant. Besides the contention that a person who has made an application pursuant to Section 14.1 has an unconditional right in terms of Section 14.1a to get the land back once the land is developed, does not stand up to close scrutiny. Where an enactment creates an obligation, the condition of the obligation cannot be ignored. Also where, as in the case of the main focus of state obligation, is an undertaking to do certain things which could result in one of several other things being done. No, it could not result in any, it result in one specific thing. It is not right to construe the enactment as creating a primary obligation in the state to do those other things. On a plain reading of Section 14, its intention is that the obligation of the state to transfer back the land to the relevant person is a secondary obligation, which can only arise from the primary obligation to consider application by that person, and to negotiate with a view to incurring any of the secondary obligation. No. This is whether any of the secondary obligations specified would have been discharged. So this is where the discretion comes. You're not entitled, if it's undeveloped, you say, no. To read the subsection otherwise would have been tantamount to redrafting the subsection. Never mind the court redrafted it. It goes without saying that had the makers of the Constitution intended to provide that the obligation to transfer undeveloped land was not subject to the contingency of consideration of an application and of negotiation, leading to a conclusion, it would, without difficulty, have so stated. As I say, I will bring a Court of Appeal which refers to that section, which says, firstly, they cannot find sense in that. I will refer to page 9, Commissioners, and the second paragraph. It is evident from what we have said that the argument that negotiation was a mere modus operandi for effecting transfer is without merit and must be rejected. It is clear that until there is a concluded negotiation, there cannot be an obligation on the part of the state to transfer back the land to the relevant person. Neither can there be a right in such person to insist on the land. This is the whole judgment will be read in the way they endorsed everything. I show that only because later Court of Appeal refers to that. So full support for everything I had read in the constitutional provision. Then, of course, it will make interesting reading. Then eventually, these and many other cases, then eventually I still insist, I bring the case of Atkinson. Atkinson has a plot of land at Beauvallo. It was undeveloped. Government said, no, Atkinson, it can be undeveloped, but we, exercising what's in their mind as their discretion, we're going to retain it as a buffer zone. Then we have the case of Atkinson, which is very, as I say, this is 2007. Of course, we lost before the Constitutional Court without saying. I have a copy for the court. As it's an important judgment, I will be reading a substantial part of it. I will be referring the Commission to page 5 to 11. Part of it is just stating the law, which we will not read. So, page 5. At the bottom paragraph, grounds 1, 4, and 5. On grounds 1, 4, and 5, the Constitutional Court's decision is first challenged on the ground that the finding of the Court that the undertaking in paragraph 14.1a of Part 3 of Schedule 7 to the Constitution to transfer land acquired if it remains undeveloped up to the date of application cannot be an obligation. So we challenge that. But only at discretion, depending on the circumstances of the case, is flawed, should be. So this was our ground of appeal. Then I submitted that this was an irrational interpretation of the Constitution provision, which contains no statement or even a suggestion or hint whatsoever as to any discretion vested in the state. That was our submission. On the other hand, the learned Deputy Attorney General supported the decision of the Court of Appeal, relying on the rationale which had been amply explained in the decisions. The above interpretation of the Court derives from a string of decisions, setting from Poglo Development Company versus AG, supported in Daniel Bonte versus government, which decided basically that the government has a discretion and not an obligation on the Part 3 to transfer back land acquired if it remains undeveloped up to the date of the application, and there was no government plan to develop them. While Learned Counsel for Appellant argues that this is a travesty of the section, the Learned Deputy Attorney General takes the view that the Court was only applying the decisions in the above cases of the Court of Appeal. The Constitutional Court indeed relied on the recent case of Georges Verlack and Government of Seychelles. So they used that in Atkinson, which, following previous case law on the matter, decided that the person who has made an application pursuant to Section 14.1 does not have an unconditional right in terms of Section 14(1)(a) to get the land back on the basis that the land is then developed, and there is no government plan to develop it. The Court of Appeal in Verlack had this to say. On a plain reading, its intendment is that the obligation of the state to transfer back the land to the relevant person is a secondary obligation, which can only arise after the primary obligation to consider the application of the person and to negotiate with a view to incurring any of the secondary obligation specified would have been discharged. This is a convenient place to reproduce Section 14(1). So the section is reproduced here up to the next page. So I'll read the next page 7, the last paragraph. The language of the above paragraph is as clear as could be and need not have spilled so much of ink. But it did. We have taken pains at attempting to understand the decisions. In our view, they come near the true meaning, but not to the true meaning of the text of the law. With hindsight, it would be true to say that the Court of Appeal in Poglo Development versus AG and Bonté versus Government of Seychelles and Georges Verlack Government of Seychelles engaged in judicial legislation by an interpretation that violates the plain text of the law. The controversy, in short, was as follows. Owners whose land had been acquired by the state under the then law, like the present applicant, has always argued that they are entitled to be returned their land where it wasn't developed, and there was no government to develop it. On the other hand, the relevant ministry had held the view, in some cases, that such an unconditional right was not found in Part 3. The Court of Appeal decided in favor of the ministry in Daniel Bonté case. It's another case which I did previously. In the Verlack case, it's stated as follows. The contention that the person who has made an application pursuant to Section 14(1) has an unconditional right in terms of Section 14(1)(a) to get back the land once the land is undeveloped does not stand to close scrutiny. This is what I had read. The court concluded that if the legislature was minded to make an unconditional right for the state to return the land, it would have said so. The reasoning of the Court of Appeal has been that the state has a discretion whether or not to return the land on negotiation or simply to offer compensation in exchange. The Constitutional Court, on the other hand, expressed the contrary view in Lise Morel versus the Government of Seychelles. And then then I read what is inverted commas. This is what the court said. Admittedly, no development between the period of the date of acquisition and the date of receipt. The state had an obligation to negotiate in good faith with transferring back the land. But that was still not successful. So we have to say that we find it difficult to follow the reasoning of the Court of Appeal in the cases cited. On the other hand, the interpretation of the Constitutional Court seems to us to be the correct one. We give our reasons. There was one statement which they endorse in the Lise Morel case, but I think it was still thrown out on another point. That was an excuse. So, first, it is true that tried law that in all situations where statutory constitutional provision gives a discretion upon any person to do or not to do anything, the law uses such word or expression as may, as the state deems fit, as the state thinks fit, decides in its best judgment. As much as we read paragraph 14(1) here, we find no such or similar language used. Secondly, we do not know how the Court of Appeal read the paragraph creating primary and secondary obligations. These terms have not been used. As much as we try to find the reasoning behind such rewriting of the text, we find none. The text is plain. It is a canon of interpretation of the legislation. The clear and plain language of paragraph 14(1)(a) did not lend to any absurdity and required no judicial acrobatics, but its simple application. Rather than reading in the section any discretionary power, we read instead the very ominous and telling term undertakes in the very first three words. The state undertakes to continue to consider to negotiate in good faith with a view to transferring. No judicial technique was ever needed to construe the true meaning of the text in the key word. The state undertakes to negotiate in good faith with a view to transferring. And then I'm going to just read the last 2 pages. What the Constitutional Court cited in the present matter to decide in favor of the ministry and against the appellant is the following. Where an enactment creates an obligation, the condition of the obligation cannot be ignored. And whereas in this case the main focus of state obligation is an undertaking to certain things which could result in one or several things being done, it is not right to construe an enactment as creating a primary obligation in the state to do those other things. It is fair to say that one is none the wiser after reading the reasoning of the Court of Appeal, which the Constitutional Court stated it was bound to follow. One faces the same difficulty in the rest of the reasoning. On plain reading of Section 4.1, its intendment is that the obligation of the state to transfer back the land to the relevant party is a secondary obligation, which can only arise after the primary obligation to consider the application by that person, and to negotiate with a view to incurring any of the secondary obligations specified would have been discharged. To read the subsection otherwise would have been tantamount to redrafting the subsection. We have stated earlier that the above is certainly not the application of any canon of interpretation that we know of. It has a remote ring of the philosophy of Professor Hart, who speaks of primary and secondary obligation in his lecture on the theory of law, as a topic in his lectures on legal theory and jurisprudence. However, in the practice of law, the more so in a court's interpretation of a text of law, courts have developed a rule of statutory interpretation such as the golden rule, the mischief rule, the purposive rule, the contextual rule, and the sui generis rule, etc. In this canon of interpretation, we have not come across and found any relevance with theories of law that may have the interpretation of text. Such an importation of is foreign to the law of interpretation. Tantamount to noyer le poisson. Exactly that. This is so true of the whole thing. Drown the fish. And we would say heretical. Academic reign supreme in the academic area and practitioners in there. Each profession mutually respects each other and learns from each other, but applies its own science. In making the decision on the matter, we take into account the clear provision of the Constitution as regards interpretation. Paragraph 8 of Section 4 of the Constitution states, for the purpose of interpretation, the provision of this Constitution shall be given their fair natural meaning. The Constitution shall be read as a whole. This Constitution will be treated as speaking from time to time. Then the last paragraph is 19, which I will read. Ground 1, 4, and 5, therefore, succeeds. In our view, that the string of cases which have interpreted 14.1 to mean that the state has a discretion in the matter should no longer be followed. Your Lordship, when I got the judgment, I read it. You know, sometimes you're happy to get the judgment. You feel vindicated. But that raised great sadness, that all these people I had fought for before were denied their rights. This is what this told me. And I had fought for so many.
But your own persistence is really quite amazing, right? That you continued, you lost the cases, you continued to go back and make the same arguments. I mean, a lot of people just would have told their clients, forget it, right? It's just going to cost you money. So that, I think, is, you should be very pleased with that.
Thank you.
I don't think I would have had that. I would have just given up, right? I mean, what's the point?
Indeed, we were.
Yeah, your
we were
tenacity is
desperate.
amazing.
After 12 years. And I knew that one day somebody would have to see the light, you know. But it was joy, but also accompanied by great sadness for the Verlacks, for the Bontes, for the Mazorkis, which had all their rights trampled upon with no comeback. because this was the end of the road in terms of judgments and not retrospective. You know, we discussed on retrospectivity a lot at the last. This is where I believe this commission has a role, as I said earlier, a role and a power, which I want to show before that even a commission must act within the ambits of what the law provides. This is what I believe this is a place for the Verlacks and the others. I will now try and move on a little faster and refer Your Lordship to judgments that followed Verlack and not Verlack, Atkinson, and expanded. First, I will share with Your Lordship two judgments in the case of...
It's not a court.
Oui. No, but I got both wrong. First, also it was in English.
Yes.
So it's a double faux. At least I was. Wait, I will share with the Commission. Yes. When you hold a judgment there, you feel like. Okay. 1, 2, 3, 4, and 5. Yes, this is the case of Robert Poole, Madam Chair and Commissioners.
Yes. So I'm trying to understand it better. Yes. Some idea.
Yes, so we have the Robert Poole case. We have two cases of Robert Poole. We have one, il y en a un qui datait le 21 avril et il y en a l'autre qui datait le 17 avril. Après, on a un le 21 avril. Le 17 avril à 2015. Voilà, si nous capables. « 21 avril 2000. Yes. N, B, 3, 4, 5. Okay. This one is 17 avril. Bapu, I will be referring to this one first. This Avril in the Poole case was a very, very important judgment. As important that Atkinson, aussi important qu'Atkinson, à cause in reverse un l'autre case dans Verlack. In reverse Verlack, un l'autre point. Alors, page 7, 8, 9. C'est là son numéro I en bas. Les autres numéros sur l'air. And this is the argument. Of course, we lost before the Constitutional Court, for sure. It was still it was felt affronted by the Court of Appeal and still carried on their mandate to support the government. So Lopez said, no, not time bar. Very important. Now, as regards the second issue of time bar, the special and dedicated constitutional cause of action contains an inbuilt time bar. The action created by Article 14.1, Part 3 of Schedule 7 relates to all applications made during the period of 12 months from the date of coming into force of the Constitution. Accordingly, no other time bar imposed by an ordinary act of Parliament or the rules of the court, which are made by the Chief Justice for purposes of practice and procedure only, could be passed to derogate therefrom. So this is when the additional petitioners...
They recognize that the Constitution is the supreme law of the land.
Finally. The applicable time bar was whether the application was made during the period of 12 months from the date of coming into force of the Constitution by a person whose lands were compulsorily acquired under the Land Acquisition Act during the period stating June 1977, and the ending on the date of the coming into force of the Constitution, and to negotiate in good faith. Then I will, next page. The question which the Constitutional Court should have simply asked are as follows. I pause here to say that they have thrown us, this case also was thrown out on time bar. The question which the Constitutional Court should have simply asked are as follows. Was the application made within the stated 12 months? Is the state negotiating in good faith? Has the eligible applicant obtained one of the remedies prescribed in the Constitution? The answer to the above are respectively. 1, yes, the application was made within the stated 12 months. On 2, no, the state has not negotiated in good faith, in that it has relied on the predated judgment to oust the applicant's claim. 3, no. The appellant is still awaiting his remedy. We hold, therefore, that the state used the wrong reason to discontinue negotiation, that the appellant received his compensation under the Land Acquisition Act. The account taken of the clear jurisprudence on the matter since did not disqualify the applicant. They had brought in a new argument that if you were compensated under the old act, they pulled everything out of the basket. You are not entitled to compensation. This was also thrown out here. Land acquisition, account taken of the clear jurisprudence of the state on the matter since did not disqualify the applicant. On the contrary, it reinforces his position. Accordingly, the termination of negotiation was not in good faith, but motivated by extraneous consideration. The appellant is still waiting for the remedy. We hold, therefore, that because the application was made within the 12 months period and the state raised an invalid ground for not pursuing the application, as a result of which the applicant is still awaiting his remedy, the state is in breach of Article 1. So this reversed Verlack on another ground. This is how bad Verlack judgment was. This is what a sad injustice. Then I will read the conclusion. The court was getting very tired with the Constitutional Court. The conclusion, the last paragraph, 28, on page 9. On the matter of Article 14.1a, Part 3, Schedule 7 of the Constitution of the Republic of Seychelles, we need to state as forcefully as possible that the sun will set on it only when the last timely application has been disposed of in good faith, and not before. That is destined to be the day of redemption of the past injustice, and no other. So the day, my very, very humble submission, the day of redemption, hopefully, will come for those that came before and had their rights trampled upon in no uncertain time. I look forward somehow to the day of reception for everybody who was trampled upon by the court, by the Constitutional Court. I had also given your lordship pool of 21st of April 2017. These cases lasted for years. The next judgment in the same case in pool is the one I gave you first. Is that it endorses the principle I mentioned before, that land sold to third parties during negotiation must be given back, taken from the third party. So I will refer the Commission to page 9 and 10. And the pages are paginated at the bottom. Nine and 10. 8, 9, and 10. 8, 9, and 10. This is referring to its bottom paragraph is T3094. We were looking to have this parcel, which had been sold to a third party, attempting to get it back, to reclaim that. In fact, it is interesting. This judgment is very interesting. We were reclaiming two parcels of land which had been sold. But one had been sold before the Constitution, one had been sold after. So with some logic, the Court of Appeal had said, if it was sold before the Constitution, we cannot reverse it. If it's sold after the Constitution, after the person has made an application, it must be reversed. So I will read page 9. Parcel T3094. The fourth respondent has submitted that parcel 3094 was transferred to it, a bona fide purchaser for valuable consideration, in December 2008, and cannot now be returned by the first appellant to the first respondent. It relies, first of all, on Section 89.2 of the Land Registration Act. Secondly, on the failure of the first respondent to self-help by not resorting to effect restrictions or cautions on the land while negotiating for its return. And thirdly, on Article 26 of the Constitution. Next page. These submissions were also made in Berry and Atkinson and dismissed. Those authorities remain good law. In both those cases, the court was categorical, and rightly so, in our view, that the constitutional right to redress for land acquisition overrides any legal right. In this case, right under the Land Registration Act. The person was registered under the Land Registration Act. The court made the point most forcefully in Atkinson that Article 26 of the Constitution cannot be used to defeat the scheme. Article 26 was the right to property. It would be perverse for the court to rely on the limitation of the right to property so as to override the government's undertaking to return land to claimants under a scheme specifically devised to remedy past injustices. So all these, the court, with respect, the courts were very, very forceful in reversing all the injustice that had occurred prior to that. And on page 10, paragraph 30 on top of the page. In effect, with regard to parcel 3094, the facts and decision of Bailey cannot be distinguished from the present appeal. The first respondent cannot be faulted for not registering a caution or restriction against parcel 3094. The fourth respondent is deemed to have had notice of the scheme and the first respondent's claim. The fourth respondent's claim should be against the first appellant, the government of Seychelles, who sold the land while it was negotiated its return to the first respondent. The court cannot connive and condone the conduct of the appellant. For this reason, we find that parcel 3094 should be returned to the first respondent. I will also give the Bailey case where the court established two principles. One principle there, that constitutional redress overrides everything. And it is so important that everybody is deemed to have constructive notice of a negotiation. In other words, the thinking is clear. If government is selling you a land, you look at the register, was it compulsory acquired? Lots of authorities are quoted, English authorities. It is a duty upon you to make an investigation. And so this was the authority for reversing judgments. One was time barred, no time bar if it's gone into the land, and I would make the parallel with Bailey, with Verlack, that it can go. I have, that is Poole, I have Bailey. Bailey also was the first authority, where the court was very, very forceful. If I may give the commission, si mon capable donne commission un copie case de lui, voilà. En Poussaken. So, commissioners, I will, this one gives all the reasons, all the valid reasons why these land should be returned. So I will leave that there, but only read one line to show how forceful the court considered these negotiations had to be in good faith and had to result in what is meant to result. On page 10,
Is that the one of Nelson Poole?
No. I've just
the Berlui one.
Berlui.
Berlui, yeah.
I will read one line which was quoted again in the Poole. And it is a line at page 10, the last paragraph, 4 lines from the bottom. To transfer land to a third party while negotiations are ongoing with the original owner for the return of the land, and then to take the position that the land cannot be transferred back, is to make a mockery of the constitutional provisions under paragraph 14, part 3 of Schedule 7 to the Constitution. And indeed, a mockery, using the word of the Court of Appeal, is what was made of the entire Schedule 7 for years.
It took them how many years?
I'm happy to use this word of the Court of Appeal. They've given us the word. A mockery
Took them
until Atkinson.
20 years to work it out.
Well, up to Atkinson was 2007, about 14 years.
From
12,
93.
13 years to work it out. The last The last case which I wish to share with the Commission, all to assist, was the case of Moulinier.
14 years.
That's the last one. Voilà. I have chosen judgments which makes very specific connotation. I will be referring the Commission. On pourrait faire commission avec page 4, avec page 4. Premier paragraphe en l'air. This is the concluding one. Page 4, premier paragraphe 6. As may be seen, two conditions apply for paragraph 14.1 to kick in so that the 1993 compensation would become payable. One is that on the date of the receipt of the application, the land has been developed. The other is that on the date, there is already a government plan to develop it. In the absence of those conditions, government is under a constitutional duty. The words are getting more precise. The message, because they are carrying on reading these constitutional court judgments that are relentless in the support of government. A constitutional duty to transfer back the land to the person from whom the property was acquired. A duty to transfer would occur even where there is a government plan to develop the land, and the person from whom the land was acquired satisfies government that he will implement the plan or a similar plan. Now, where the land cannot be transferred because the case falls outside those situations, there arises a duty to give full compensation in cash or in kind, either transferring to the person or the parcel of land or of corresponding value to the land acquired, or paying the person full monetary compensation for the land acquired, or developing a scheme of compensation combining item 1, 2, up to the value. This is authority for reinforced authority, but also a very important point which this one settled, a point of great contention up to 2016. We are now in 2016. That is, Atkinson was 2007. So that is 9 years later. There was still a point of contention, and that is, if you pay compensation at what value?
Yeah.
This
Also an issue for us.
This schedule says 1993. So I refused in one case, and I refused in this case, because there was a lot involved. And my argument before the court, and I sent a very big argument in writing, was this: look, why did we say 1993? 1993 was a prospective provision to say that if it was acquired 10 years, 12 years before, the compensation, the new compensation, will not be at the date of acquisition. It will be at the current market value. 1993 was the current market value. So, if the government has taken 20 years or 10 years to settle, now we're going back to the same ill that we tried to cure. We tried to cure retrospective values with current values, that we were hoping, by the way, when we discussed that after the Constitution, it would take 1 or 2 years to finish. After 10 years, the same ill crept into it. We now had retrospective valuation to 1993. So I argued that. Unsuccessfully in many cases, but finally in the Moulinier case, I will refer now to, that's in 2016, paragraph 5, page 5, paragraph 10. And this may be also a point for the Commission if it considers compensation. We should state that fine point, anxiously raised by learned counsel for the appellant, is not readily apparent to the unguarded. Indeed, there is more to paragraph 14.1 of Schedule 7 of Part 3 to the Constitution than meets the eye. Could the framers of the Constitution have created a regime in the schedule to the Constitution, which was in derogation of the constitutional provisions regarding the fundamental rights and freedoms of the individual? Our answer must be in the negative. The 1993 Constitution regime could only be a reaffirmative of an extension of those rights to pre-1993 events, in keeping with the right to property enshrined in Article 20 of the Constitution. Part 3 was a redeeming tour de force meant for the retroactive correction of past injustices along the newly introduced democratic principle. This is amply reflected in the choice of the title Compensation for Past Land Acquisition. The content of the provision in the specified implementation provisions designed to redress all wrongs. It cannot be used today to perpetrate those wrongs, nor to create new wrongs. Why was the date of 1993 introduced? Only to ensure that the compensation due was to be awarded on the basis of the current rate compensation. It was 1993. It was meant to dispel any doubt on whether the compensation for the application for past acquisition should be made on the basis of the time of the acquisition or the time of the application, which was 12 months after the coming into force of the Constitution in 1993. It basically preempted and settled any dispute that no matter what were the date of the acquisition under the Land Acquisition Act, the rate applicable should be 1993, thus consecrating the universal principle of current rate compensation. So they said behind it is current rate compensation, and they awarded Moulinier the current rate, rate at the date that it was valued after filing the petition.
Of 2016.
Yes.
Yes.
So basically, I've chosen judgments which I believe settled all those all the injustices that had occurred prior to 2007.
Mr. Boulay, if I may, in paragraph 6, I think there's one injustice which has not been addressed yet.
Mm-hmm.
It says, there arises a duty to give full compensation in cash or in kind, either transferring to the person another parcel of land, and it carries on.
Yeah. This is in the Constitution. This is in the schedule.
Yes. That
They have that option.
the duty to, yes, to pay or give back. But the duty, is there a way that the government can say, we don't have the money now, we'll pay later on?
That was debated. In fact, heavily debated in Moulinier, in Poole, where very big sums were awarded because very, very valuable properties. In fact, we We did not go to court. We argued with the Ministry of Finance. And one had 4 years, one had 3 years, and then I argued with them for interest. And I think we got 6 for one. I think it was 6 or something. So we gave a schedule of 6 months monthly payments with interest. This was an amicable settlement which I had on behalf of my clients with the Ministry of Finance. It was 6 monthly with commercial interest, and they paid, and both cases have been fully settled. Both of them had part return of land and part. In fact, lots of land had been sold in the Moulinier case after the application. But because they were for housing, we didn't even argue. We said, Seychellois living on there, we have a right to it, but let us not make a meal out of that. Let's just claim compensation for parcels that had been sold to Seychellois, even though illegally. So we had then this amicable settlement. No, government cannot say it cannot pay. It's a debt on the state. The state has got a constitutional obligation.
There's been no court of appeal ruling on it.
Somebody waiting outside.
If there is a ruling,
No, so far there has been no case that's gone to the court of appeal.
well, no case has gone to the constitutional court. Usually, what would happen? It would not go to directly the court of appeal. It would be by way of an enforcement of judgment. And there are certain issues that arises specifically with enforcement of judgment against states. You know, interstates, they seize aircrafts of one state in the other. There are certain very specific ways to enforce. It would be by way of enforcement of the judgment against the state. And usually then the courts would not directly meet that, but once you enforce, there are contempt issues that arises. So this would be the way forward. They have, as I say, when we say compensation, they can give a piece of land, or they can give that, or they can give that. So that will be, I think, the most important, if there are awards to be made of compensation, is to make it, and then the person, as in a court of law, would seek its enforcement of the judgment. It has, well, you know, it's this is particular sad case. There were others very, very sad case. You know, where this old lady had worked so hard. She was in the final years of her life. I met her afterward, final year of her life, a wonderful, dignified lady. I called out, you know, the Verlacks. You know, you're all families of Poile, who all aspired, you know, the families of Poile. I knew the Adeline well, the Verlacks. Of course, I knew the Green family. We went boarding school. We slept in the same laundry. All these families of Poile, or people that were very hardworking. They're very hardworking, in whether it's fisheries, agriculture, everything they had worked very, very hard. And one of the things, I must say, one of the beautiful preoccupation of the families of these times was to look after their children, was to educate their children, educate in not academically and at home. And all these children today have turned out to be very dignified, honest children. You know, and this the Verlack, this is what, and all the families that contributed to this society, working hard, raising their children in respectable, honest people, and their government treats them like that. It is, oui. Oui, m'on dit triste, m'on dit très triste, ça clair nous guette, et madame comme madame Verlack. Il travaille avec son mari en premier, et en plus il devient veuve et il continue à travailler pour acheter la terre, pour soigner sa famille. Et ça, c'était, pareil, m'ont dit, c'était caractéristique d'une famille, enfin, le maïs, mais le pralin. Bonne famille qui moi, tu connais pour aller, bonne Adeline, famille Verlack, famille Green, pareil, m'ont dit, bonne parents qui travaillent très, très dur. Les autres, en ont un tellement noble. Toute la bande, c'était pour éduquer les enfants. Pour faire les autres enfants, une bonne, du monde respectable, du monde honnête dans la société. Et moi, je crois que c'est sa plus grande contribution qui sa bonne du monde fait. Il crée bon citoyen honorable, bon citoyen respectable, avec beaucoup d'intégrité. Moi, si mentionné par hasard, mon compte bonne famille, mon compte famille M. Green aussi. Depuis bien zen, M. de boarding school, lié avec son frère. Et les autres familles, mon compte plus tard, les Verlack, les Adeline. Et il est regrettable qu'ils s'abonnent du monde après la vie comme ça, qu'ils ont traité de sa façon. Il est répugnant, il est triste. Et c'est pourquoi moi, je venir avec beaucoup de plaisir pour aider pour quelque chose qui choque moi, qui fait mon chagrin, pour que nous soyons capables de mener la clarté et la justice, pour qu'il mandat sa commission, enfin de mon très humble opinion, dans le mandat sa commission, il trouve son plein épanouissement pour le monde.
Bon, tu as une petite histoire qui te fait qu'il est dans les années 60, qui montrait comment sa famille Verlack s'est attachée avec la terre. Tu as sa millionnaire sud-africain Oppenheimer. Il est venu, tu as là, et tu vois que l'Aslagio, et tu vois que là-bas, isolé, Verlack, c'est une propriété là-bas. Tu fais les autres 1 million de livres sterling à l'époque.
Wow.
Et en même temps, tu es capable de garder la case, continuer à rester là-dedans, escalader les autres derniers jours. Les autres refusés.
Incroyable. Mais ça, il montre une mentalité. Il y en a quelque chose de sa mentalité là qui est dans la tête du monde. C'était non seulement les autres qui travaillent pour élever les autres enfants, pour éduquer les autres enfants, mais il y en a dans votre l'esprit pour passer quelque chose avec les autres enfants. Il est beaucoup plus important qu'ils autres en ont sur la terre. Là. Ils représentent le travail dit. Et les enfants grands, ils ont encore ça l'espoir. C'est tellement noble. Par exemple, les bons enfants, ils ont un bout. Et la raison pour aller, à cause de la terre qui nous nourrit les autres. C'est une valeur. Ce n'est pas qu'ils ont contre la terre pour n'importe quoi. Tu mets un valet, c'est ça qui nourrit les autres, c'est ça qui nourrit les autres enfants. Il faut espérer que les enfants grands sur la terre pour nourrir. Mais ça, c'est une réaction très, très noble. Pareil, nous dit en anglais, speaks volume. Et nous, ici, nous arrivons, nous rassons du monde sur la terre, nous prenons les autres, nous mettons dans le casson. Enfin, il faut espérer qu'on est capable et de commission un petit peu.
Nous apprenons en quantité.
La documentation, c'est appréciable.
I hope you enjoyed.
Un gros effort, une grande contribution. Merci beaucoup.
C'est mon plaisir. Il y a des autres pour sa caisse, c'est qu'il faut les autres caisses. Toujours un plaisir pour être commission de son travail.
I mean, it's fascinating. You know, it's a really fascinating legal journey. I think it says a lot about the government, which, you know, I think the government, you know, based on the positions they were presenting were quite unconscionable, given the intention behind the original constitutional provisions as we understood them. But we will definitely have a chapter on this whole development in our final report, of which we will probably seek your assistance in reviewing. I think we've discussed this before about calling upon you, but we want to make sure that we get things right. Yeah.
It would be a pleasure. And in the Verlack case, as I say, just to close, there is power as the law provides to, it was that which I had in mind. There is a power, of course, the Commission will decide in its own sovereign way to make orders against third parties. And it was on that basis which I brought it forward, that there is a legal principle now, that orders can be made against third parties. And if I may add what I, again, humbly suggest, if an order, Verlack or any other, were to be made to take land from a third party, subjected to the caveat that it was acquired during the time of the negotiation, back to its owner, the owner should not have the obligation, si la terre il prend avec un tiers parti, il rend avec sa propriétaire, mon succession c'est qui, sa propriétaire, pas supposé rendre ça là au gouvernement. Si le gouvernement il donne bien compensation. Ça, il y avait une sorte de compensation pour les faits qui perdent la jouissance à la terre. Présent, lui, sa propriétaire, il a acheté la terre en faux, lui a fait la guerre gouvernement. Voilà une suggestion manière pour voir liablement dans sa contexte Verlack et les autres.
And it's the government that bears the responsibility of that loss because it's their unconscionable conduct that led so that person would have to issue the government.
Precisely my thinking, Madam Chair.
I mean, it's very interesting. So thank you so much for.
Pleasure.
We knew bits and pieces, but we didn't really have like a comprehensive overview that really creates a very clear picture, I think, as to the progress. And it's lucky that the tide turned, right?
Yes.
And your persistence, you must be congratulated. Unbelievable. Unbelievable.
Merci, Madam Chair. Perseverance.
No, so we have no more questions, unless you have anything you would like to add.
No, I think I've only to thank the Commission for the opportunity to address it, to assist with the Verlack case, which is a meritorious one, in my opinion, and also to assist generally with other cases. Thank you very much for the opportunity. It's always appreciated, and it's always a pleasure to appear before the commissioners. As usual, bon courage and all the best. Yes.
Thank you. I'm glad you say that because we've got you coming back again on Thursday morning, right?
Oh, that's true. Oh, that's true.
So I'm glad
Yes,
it's a pleasure
yes,
because
yes.
it's a lot of time we're
Thanks
taking
for
from you this week.
Another thing that ended with a compulsory acquisition, but going through other
Yeah.
routes.
Thank you so much.
I'll see the
Yeah, we look
commission.
forward to that, but for now we'll adjourn just for 5 minutes. So we'll be back at 3:35. Okay, thank
All right.
you.